because it is in the youth that you pick up a pulse of society. If you invest in young people, your future is guaranteed. If you invest in young lawyers, it is guaranteed that you'll produce strong, homegrown talent. And your senior leadership of the profession and the judiciary's health will be guaranteed. And I really wish to congratulate you as young lawyers for taking to heart the very important exercise of training. Simply wish to mark out two important things that you must bear in mind as you progress this journey of legal practice. The first is that you have to be patient, because the results are not guaranteed in one day. It's not that exercise of going to a stock exchange and bet on a share. Better still, thank you. That's how we speak as lawyers. There has to be a lectern in front of you. Or going to bet on a lotto and become a lucky winner of a mega jackpot. The profession requires patience, and it's a long-run exercise. And I think that if you bear those two considerations in mind, you are guaranteed to become a very important contributor to a healthy profession and healthy judiciary, and therefore not invite at all costs and time someone like Griffiths Matonsela from South Africa to try and litigate in Namibia. He's my wonderful friend, and I remember that he and I spent almost, I think it was 6 months, trying to defend then Commissioner of South African Police Service, now Minister of Police, on allegations that were made about his leadership of the police service in South Africa. We failed to successfully defend him before the Board of Inquiry, but ultimately in a review, which is the subject matter for discussion today, we succeeded. And as I recall, Griffiths, that review was not opposed.
Opposed, but they relented.
Yeah, it was opposed, but when we got to court, the result was obvious. I did not arrange for Griffith's presence today. Let me make a second public confession. He so happened to be here when I'm here, but like all good friends, we follow each other wherever we are. And the last introductory remark I wish to make is that it's always a privilege to stand before you. I think this is the third occasion I stand before the gallery in this place. On previous occasion, I was looking to this side. I'm not too sure whether it's the east or west, but this time I'm looking this side. I'm not too sure whether it's north or south. Just to not only talk to you, but learn also from your experience, so that our discussions today should not be seen as some form of a speech. It should be a discussion, and feel free at any point in time to intervene, ask questions, and I will step off my little nose that I have cobbled for this occasion. So feel free to ask any pressing question you may have at any point in time. For my part, I will be disappointed if there are no questions, if not in the course of our discussion, certainly at the end of it. So I expect more from you than you expect from me. What I propose to do is to talk about reviews on 3 subjects. The first is to track and trace the philosophical foundation of reviews as a form of judicial process, inviting one arm of government to intervene in the affairs of other arms of government. I hope to suggest to you in due course that the traditional lines of review intervention by the judiciary are no longer the only means of invoking review powers of a court. Matters are progressing to invoking review intervention powers of a court into quasi-private public law relationships, and more recently, into private law relationships, because private sector is gaining far more power than the public sector. More recently, because of the expertise of private power, public entities delegate their public power to private powers. And that is so essentially in generally democratic states which do not have capacity to deliver their services or rely on the expertise of private sector power to assist public entities to deliver their services to ordinary people. So please forgive me if I were to sound professorial by engaging in the philosophical foundations of reviews. But I hope ultimately that debate, in the end, will provide us with a level of understanding so that we protect all of our clients in regard to the exercise of power, be it public or private or a mixture of both. That's the first type of subject I'd like to explore with you. The second relates to the mechanics of review. And there I would like to explore how you can use those mechanics for the benefit of your client, whether you are a litigant who initiated and prosecuted a review, or you are defending a review brought against your clients. There are a number of tactical decisions that arise on that score, which would require the exercise of the better part of your legal discretion, not only in advising your client, but also in protecting his or her interest. And the last subject that I'd like to talk about in connection with reviews is the question of remedies. It is one thing to go to court, plead a ground of review and win it, but in the end up with a remedy that does not talk to the problems of your client. In fact, what we have come to learn is that before you even start thinking about formulating a review application or a review defense, the key thing that you have to think through properly, spend a bit of time on it, is the question of remedies, because remedies are ultimately what your client has engaged you for. There are cases, and I'm running ahead of myself, where a review applicant has won and has persuaded a court that their grounds of review are well-founded. But in the end, the court declined to grant a remedy in favor of that review applicant because the court generally understands that a review is a public law or public/private law remedy of discretion. it can be granted or be withheld from an applicant at the discretion of the court. And so my suggestion is that before you even think of formulating a review application, spend a bit of time to think through the remedy that you would like to plead and prosecute or defend on behalf of your client. And there the tactics go both ways for a review applicant and a review respondent. I'll share some of those tactics with you, and it's a subject matter which I believe will elicit a measure of lively debate as we talk about it. So on the first subject, the question of the philosophical foundation of reviews. Thank you. The traditional justification is that a review is a judicial tool or legal process in order to protect and promote the rule of law in a constitutional democracy. We now know that in the context of constitutional democracy such as Namibia has, the voting population invest a mandate in a political party that emerges successful in elections. And part of that mandate is that the political party concerned will be entitled to exercise public power invested upon it in terms of the Constitution and a number of instruments that regulate the exercise of public power. And part of it will be that the party in government will be entitled to establish its own bureaucracy in order to exercise administrative powers. And it is that body of the wealth of public power which will become the center and front of reviews whenever people get aggrieved by the exercise of that public power. And for instance, if you apply for a license of whatever kind, if you apply for a permit, if you apply for a passport, you may not get it. But if you feel aggrieved by that decision, review provides a tool for you to challenge the exercise of that public power. And in that sense, it is a democratic compromise to promote a rule of law, so that those who exercise the power should know that they must do so within the limits of the law, and they must do so in a manner that is rational and justifiable. So those are the traditional lines of the justification for review on a philosophical basis. The second justification, which is emerging in the context of the constitutional debates that democratic countries are realizing, is that review is an important moderating tool for the exercise of power by one arm of government against the other. We all know that in a democratic country, the principle of separation of power is quite important. That one arm of government does not unduly intrude into the exercise of power by another arm of government. But reviews present an opportunity to moderate the extreme consequences of a separation of power, so that if one arm of government does not properly and legitimately exercise its own powers, a court may, in appropriate circumstances, intervene to correct that improper, unlawful, or unjustified exercise of power. You see the manifestation of the remediation of the extreme nature of separation of powers, generally in the context of exercise of administrative powers. But these days it goes further. Courts may well intrude into the exercise of executive powers where there is a legitimate basis to do so. Even more recently, courts may well intervene in the exercise of legislative powers. I don't want to open up old wounds. I will leave the discussion on that score. I will simply note that courts, especially courts that are active in democratic trends, do generally consider it their constitutional duty to intervene in the exercise of legislative, executive, and administrative powers in moderating this principle of separation of powers. One key question is, who intervenes when the judicial arm of government does not properly exercise its power? It's a controversial subject. I would not get into it. Safe to say that there may well be circumstances where a litigant may approach a court in order to correct excesses of judicial exercise of power. The gateway to review, in traditional terms, and judicial scrutiny in a review process is about the exercise or failure to exercise public power. I've already indicated to you the manifestation of the exercise of public power. It is either legislative, it is either executive, or it's about administrative action. And it is at that level of administrative action that ordinary people feel the weight and burden of the exercise of public power. It is no surprise when you look at the law reports that in every law report you will find at least two or a minimum of two cases on reviews, precisely because it is at administrative law exercise of public power that you would find reviews utilized in order to correct the improper exercise of public power. I'm not going to engage with you on what constitutes the exercise of public power. I mean, we know that courts have grappled with these over decades. I would simply mention three tests which I know that they have been adopted in this jurisdiction. And they were formulated somewhere in Australia, given the transatlantic wisdom they profess to have on this subject. It is the so-called control test. Is the decision maker subject to control by public institutions or public entities? The second test is the functional test. You ignore the actor who is the subject of the decision sought to be reviewed, and you look at the nature of the function. Is the function public in nature? And if it is, then you may meet that functional test. The last is the purpose test. You ignore the nature of the person or entity. You ignore the source of power. You look at the purpose of the power. And if you meet that test, then you may well convince a court that there is public power worthy of intervention by the judiciary. Those traditional lines of review intervention by the judiciary are no longer justifiable in the light of the modern state that most countries live in, because private sector power is becoming as more powerful, if not even more powerful, than public sector. And the courts are now beginning to grapple with the breadth and length of private power in the course of engaging in review proceedings. I would give you 3 examples of instances where private actors have taken decisions that have become subject matter of review proceedings, sometimes successfully, others not. The first of those instances will be a private actor who exercises a power which has mixed features of private law and public law relationship. Give an example in a moment. Take, for example, the profession to which we belong. I'm told that it is here established by statute, but there are voluntary associations within the statute, accredited by the governing body. But at that level of voluntary relationship, it is exercise of private power. You choose to associate or to dissociate. But once you associate, you're subject to the rules of the voluntary association. But that association has the power of discipline, and it has the power of accepting or refusing invitations. The key question that you will confront, and I'm sure that some of you have confronted it, is whether when you apply for membership and they refuse you, can you challenge the decision of that voluntary association to refuse your membership? Or you are accepted as a member, and for some or other reason, your ethical conduct becomes a subject matter of investigation and scrutiny. Would the rules of the private voluntary association consent, which say that you're not entitled to a hearing, and they can dismiss you, or they can terminate your membership without a hearing, become a subject matter of scrutiny and review? So that is quasi-public power. You'd find generally that those powers of discipline, membership, or regulating relationship as between colleagues are generally formulated through some kind of a code of conduct or are sourced from a statute. And in that context, my suggestion to you is that the bright lines of public and private powers are no longer clear, but a very inventive lawyer may well invoke the process of review in order to challenge the excesses of exercise of private or quasi-public power by a voluntary association. There are instances where you find that an organization is truly private by its nature. And yet, because of some reason, including lack of capacity, that organization invested with the obligations to fulfill public functions and duties. I'm not too sure here in Namibia, but in South Africa, I'll give you 2 instances which I suspect replicate the experiences here in Namibia. We have the so-called Social Security Agency as part and parcel of the social welfare system in a country, and it is regulated by an act of parliament, and there's a ministry established in order to provide those social welfare programs to mitigate the excesses of poverty. But the ministry does not have capacity to go and discharge payment of the grants because you require logistical and distribution capacity. And the ministry went out to tender to appoint an entity to assist it in distributing monthly payments of social grants. And the courts have held, without difficulty, that that private actor, in that case a bank, is fulfilling public powers when it dispenses social grants. And its decisions on that score are subject to review. The second example I can think of is the so-called Gautrain development. I think we all know that when you get to O.R. Tambo International Airport, there is a railway line that takes you to at least Sandton or Rosebank. That is a project which was conceived by a provincial government, and there was a provincial legislation promulgated in order to give effect to that project. But there was lack of capacity within the provincial government arrangements, and they had to appoint a number of experts and agencies to execute that project of Gautrain. And the number of cases around the decision taken by the consortium, which was in charge of that project, which had become the subject matter of review and at times arbitrations. And so it is another example of a situation or arrangement where a public entity invested with original or statutory powers invest them to a private sector so that those functions and duties can be fulfilled effectively and efficiently. And that private sector acquires and assumes the obligations of the public sector, which, if not fulfilled properly, will become the subject matter of review. But there is a third instance which has now confronted us and has become a playground of is in those instances of truly private law relationships, where a private actor takes a decision against a counterparty. And the question is whether or not that decision may be open to review in a manner that a public law exercise of power may be open to review. And I can think of two examples where the courts have grappled with that issue. The one is the recent case of Makata versus Vodacom. You will recall that that's a judgment or litigation involving a very inventive and creative young man who is accredited with the invention of please call me back technology. If you have a cell phone gadget, it is not loaded with airtime, you can't make a call, you can use his technology to dispatch a message to another person and ask them to call you back. And as that person calls you back, the network operator who owns the line that you use to make a call back earns income. And Makate was accredited with the origination of that technology when he was working for Vodacom. And in the end, he claimed money from Vodacom. And Vodacom, over the years, refused to acknowledge his entitlement. But in the end, the Constitutional Court found that he was the originator of the technology and ordered that he is entitled to reasonable compensation. The key question which arose is, in what amount and who determines it? And the Constitutional Court devised a private law relationship of resolving that dispute to say you must negotiate as private parties. If you fail to negotiate an outcome that is successful to both of you, then the CEO of Vodacom will determine compensation payable within certain parameters. Next round of litigation is that the parties fail to achieve successful negotiation. The CEO decided to award what he thought was reasonable compensation to Mr. McCarthy. And to give an example, the CEO decided an award or compensation in the order of, and I'm guessing now, don't hold me to the figure, but it's an illustrative amount of 20 million rand. And McCarthy says, to hell with you, I deserve 20 billion rand. And you can see how apart they were. And McCarthy decided to institute a review to review, correct, and set aside the decision of the CEO because he thought that that was not a reasonable compensation ordered by the Constitutional Court. And review litigation commenced in the High Court. And the High Court found for him and ruled against the CEO by way of a review and re-established the parameters of reasonable compensation via the order of the Constitutional Court. But the point at this stage is that there are areas of private law relationship where courts feel comfortable in intervening. I must not leave you with an impression that that is a well-established jurisprudence in our country. The McCarthy judgment was argued in the Supreme Court of Appeal only 2 weeks ago by some of the very creative and well-known lawyers. And I confess, Griffiths, that that might not be the end of litigation. It will have to go back, second round, to the Constitutional Court. But again, that shows you that private law relationships are not free from review intervention by the courts. The second example of areas of exercise of private law powers between private law actors, where review powers of the court may well be engaged, are in relation to contractual matters that contain clauses that offend public policy, or clauses that become overburdensome to a counter-contracting party because that party was in an unfortunate bargaining position when the contract was concluded and therefore would have to suffer the consequences of the strong bargaining power of his co-contracting parties. You find that, and please don't, I'm not offending anyone, simply mention it as part and parcel of the reality of our modern state. You find those type of clauses in banking arrangements. None of us have the power to negotiate the terms or conditions of the banking services extended to us by the bankers. You find those type of clauses in insurance arrangements where you are told that regardless of circumstances, if you launch a claim, you must do so within the month of the occurrence of the event giving rise to a claim. And you have to comply with many other things. And life being what it is difficult to formulate a rule which applies in all circumstances. You also find those types of clauses in general credit arrangements where you apply for a loan and you get it. I know that some of the countries have formulated consumer protection legislation. And we have 2 of them in South Africa. I won't bore you with them. But those type of legislative interventions are designed to protect consumers, especially those consumers of credit. But often than not, the loans concerned will contain clauses which deliberately or otherwise deprive credit consumers of the protections they have. And the key question is, if a credit provider decide to withdraw credit or terminate a credit arrangement, can you, by way of review, ask the court to intervene? Courts have grappled with that issue in our country, and some of the courts have intervened. Others sadly have not done that. But the point is that right now, the debate about whether a power is public or private in order to engage a review process and remedy, it is no longer a viral debate. Of course, I'm not suggesting to you that it is not an important debate. It is there, but for a creative lawyer, that debate is no longer essential because courts would generally intervene when there is a cause for intervention by way of review. I will leave you with this thought, that if a client approaches you and is aggrieved by a decision made by a public or private actor, or a quasi-public-private actor somewhere in the middle of the two extremes, do not dismiss the cause of that client because the decision that he or she complains about has been taken by a quasi-public-private actor or a private actor in the true sense of the definition of the person or body concerned. Think through quite carefully around whether or not you can devise review intervention by looking at, firstly, the source of power. Where does the private actor concerned derive his or her power from? Think through about the relationship concerned. What was the nature of the relationship which gave rise to the decision concerned? Was it a relationship based on equal bargaining power? Or was it a relationship which is based on the imposition of power by one against another actor? Think through about the intervention that you seek the court to engage in, given the far-reaching impact of the decision of concern to your client. And lastly, think through about the public importance of the decision concerned, because it may immediately affect your client there and then, but it may have far-reaching public consequences for others of a similar kind down the road. And it may well be that you may want to use your creative skills in order to engage the court's exercise of its review powers, regardless of the fact that the actor concerned and the decision maker concerned is not a true public body or entity. I'm going to go to the next topic about the mechanics of the review. I assume that there are questions, and if there are, please feel free to ask them. The second subject I'd like to talk on relates to the mechanics of review. We know that generally in a review, you start with your founding papers, and there will generally be complaints that are generalized, unsupported by critical evidence. There's nothing wrong in it, because a review provides you with an opportunity to source and extract information from a decision maker, from which you can assess whether or not you should proceed with your review. And it is at that part of a review process that a decision maker is called upon to do two things in general terms. One is to produce the record of proceedings, And secondly is to give reasons which he or she is required by law to give, or absent a legal duty, he or she thinks that they want to give to the court. And therein lies the importance of the mechanics of a review process that raises a number of tactical considerations you would have to take into account, either as a review litigant or an opposing litigant. And the first issue that arises is, what is the record of proceedings? Once you launch your review founding papers, you are entitled as a matter of right to access of record of proceedings and the reasons. The decision maker has no discretion. They are obliged to produce the record of proceedings. The debate always emerges about what is the record of proceedings. A review applicant has an incentive to expand the record of proceedings. They want to get each and every piece of paper which was at the disposal of the decision maker, regardless of the fact that the decision maker may not have looked at that paper to arrive at the impugned decision. The incentive on the part of a review respondent is to contract the record of proceedings and reduce it as much as possible. And therein lies the tension that gives rise to questions of tactics. You may choose as a review applicant to litigate on what should be a complete record of proceedings. And in that context, you start a new frontal debate around the record of proceedings, which acquires a momentum of its own. There are, of course, consequences to it, because once you start that type of litigation, it may outstrip and surpasses your main review. Generally, decisions that are subject to review are often time-based. Take, for instance, an award of a contract. It will be about a project which is time-based and has to be executed and completed. Illustratively, let's say 2 years. If you start a debate and litigate around a record of proceedings in a manner that eats into that illustratively 3-year period, by the time you succeed and get it to the main review, the execution of the contract may well have been concluded, and therefore there would be no point in proceeding with review. And therein lies the tactics about how you deal with concerns about the record of proceedings. You would recall that the civil form of litigation we have is divided into 2 general patterns. One is motion proceedings, where you litigate from the beginning to end on paper. There's no need to call witnesses. And the other form is you start proceedings by way of pleadings, basic structure of the case and defense, and you end up into pre-trial discovery processes, calling for production of documentary evidence, and end up going into court. Witnesses testifies. The judge has regard to all of those materials, pleadings, discovered documents used in trial, and evidence, and decides a case. But reviews are a hybrid form of proceedings which stands in the middle. It helps you as a review litigant to start a case on motion, that is by paper. but affords you the advantage of early discovery of the information at the disposal of a decision maker in order to assess whether you have a good or bad case. It also affords an opportunity to get the reasons. So as a review litigant, it is important to use that hybrid form of litigation to your best advantage. But we know that review respondents are not always cooperative. At times, they don't produce a complete record of proceedings. At times, they don't give you the reasons. And at times, they wish to withhold information on the basis of confidentiality. And the key question is what happens? By the way, confidentiality is not a ground to refuse production of the record of proceedings, but it raises legitimate concerns on how you produce the record of proceedings. So as a review respondent, tactically, I would suggest that you meet your obligations of producing a record of proceedings in full by dividing the record of proceedings into two parts. The non-confidential version, which you give to the review applicant without limitation. And the next is the confidential set, on which you regulate the nature and extent of access to the information, subject to protection of confidentiality. It may be confidentiality of your client, or it may be confidentiality of commercial and trade secrets of third parties who may have engaged in a procurement exercise, and they may have given you as a decision maker the information on the basis of confidentiality. And on that score, you are entitled as a review respondent to produce the record on the basis of confidentiality. That an applicant who may be one of the aggrieved participants in the procurement process must not gain whole access to confidential material. And you may wish to regulate access of confidentiality by calling for confidentiality undertakings, so that if confidentiality is breached, you may well be entitled to sue those who breach confidentiality. And so, assuming there is cooperation, assuming that the record is there in full because it does not have confidential arrangements, or assuming it is there in a divided form, confidential and non-confidential, how do you plead your grounds of review based on the right to supplement your grounds of review? I think tactically you must bear in mind that if there is a confidential record, you're not entitled to mix your pleadings and make use of confidential information to plead supplementary grounds of review in your supplementary affidavit in general terms. You will be required to plead supplementary grounds of review by maintaining and protecting confidentiality. So you will then have to have two forms of affidavit. The one pleads your supplementary grounds without restraints on confidentiality. The other deals with confidential matters. And generally, those would be matters that require the use of experts. And you plead those additional grounds of review through a confidential supplementary affidavit and make sure that you protect it. Lawyers who are cooperating with one another in review process involving confidential information will devise a regime through which confidential affidavits do not form part of the public record in court. There is something called the Crown Cock. I don't know if you know it. We refer to it as a Crown Cock regime, which is basically a type of confidentiality order determined years ago in South Africa by a judge. I remember Griffith, I think it is Scott. Do you remember him? Scats, he was a judge of the High Court at the time and rose to become a very influential member of the Supreme Court of Appeal. And that form of confidentiality regime order has outlived him. And it is important because it sets out the terms and conditions around how you protect confidentiality in litigation. I mean, to give you the worst example of how Crown Court operates. In court, when you debate, I mean, a court is generally a public place. The public is entitled generally to go into court to hear a case and hear lawyers with forensic skills of persuasion, especially if you pay them. Now, you get to a point where you have to debate and persuade a judge about the cause of complaint or a review defense on matters that are confidential. You're not entitled as a lawyer to breach confidentiality by dealing with confidential matters in the presence of the public gallery. What do? Well, Crown Court tells us that you may have to ask the judge to clear the court and clear the public gallery and allow only persons who have a material interest in the confidentiality to follow the debate. And that's Crown Court for you. But bear in mind those tactics, because generally review respondents have an incentive to try and protect information by way of confidentiality or to refuse to produce relevant information. Simply leave you with this about what is the record of proceedings. Courts have engaged in that debate for so long. But, lawyers have always said that the record of proceedings is every piece of scrap paper that was at the disposal, and I repeat, that was at the disposal of a decision maker, even though the decision maker may not have had regard to it. In South Africa, we have had debates around whether when decision makers retire into their deliberation rooms and keep their notes around what the deliberations are in order to persuade each other, is the record of those deliberations part and parcel of the record of proceedings. I think you know the famous case of the Cape Bar Council versus the Judicial Service Commission. You can follow that debate because though the Constitutional Court attempted to, it did not resolve the controversy, and the debate rages on. There is another judgment of Sun International versus Mpumalanga Gambling Board, where for reasons of perceived accountability, the Gambling Board decided that not only are they going to record their proceedings vocally, but they are going to record them visually. And some of the members were captured on camera doing things that I would not encourage you to do in deliberations. And the key question is whether those visual material are subject to record of proceedings. Hot debate. Bear in mind as a review litigant that you may wish to protect those types of unseemly visual material as part and parcel of the record of proceedings. I would like to end up my views on the second subject around the mechanics of the review by suggesting to you that if you are a review applicant, don't be trapped by the tactics of a review respondent who does not wish to cooperate by producing either the full record of proceedings or a divided, non-confidential, and confidential parts of the record of proceedings in time. Because if you were to play into those tactics, your remedy may become ultimately fruitless. I suggest to you, if you're a review applicant, that even with a limited record of proceedings, plead your supplementary grounds of review, but do so provisionally, and make it quite clear that your supplementary papers are provisional, subject to a further supplementation once the debate around the production of the complete record of proceedings take place. So you may wish to engage in two parallel processes. You plead your provisional supplementary grounds of review. At the same time, you initiate an urgent application to compel full production of the record of proceedings so that you preserve the integrity of your review remedies in due course. If that tactic is unlikely to work given the constraints of time, I would suggest that you should initiate an interdict midstream the review proceedings and stop the implementation or effectiveness of the decision that you seek to challenge by making sure that a review respondent does not lull you into a progressive delay for the determination of the main review proceedings. Some creative lawyers, they start review proceedings at the same time with an interim interdict in order to stop the implementation of the decision. Of course, that is a useful tactic, but there is a danger in it. Because if you start that type of hybrid litigation, interdict pending the outcome of review, I think they call it Part A and Part B proceedings, I don't know why, but that's the lexicon that we work with. If you do fail in an interim interdict, the legitimacy about your review becomes questionable. And be careful to start that type of hybrid process, unless you're convinced that you have a strong case. And my experience is that interim interdicts, pending reviews, are generally not treated receptively by our courts. I'd like to get to the third subject, which is the question of remedies. And I've suggested to you that remedies are quite important in review proceedings, because a review is not a remedy of right and wrong. It is not like you go to court and say, the man owes me money and I've established liability and therefore I'm entitled to judgment for payment of money in the amount you claim or are able to establish on evidence. I've suggested to you that it is a remedy of discretion that a court may grant to the right review litigant in the right circumstances or proceedings, and it to be just and equitable. I'll repeat myself. Review is a remedy of discretion which a court may grant or withhold to a right litigant. Because by a right litigant, I mean a person who has the appropriate legal standing to approach a court for a review remedy in the right circumstances. And by that I mean circumstances that engage the court's jurisdiction to exercise its review powers, and for appropriate remedy, which is just and equitable. It does not follow that in each and every case where you establish your ground of review, the court will give you the type of remedy you want. The court is entitled to creatively devise a remedy that it considers just and equitable. And you can see the foundational basis of that remedy Because once you start review, and absent an interdict, the normal legal position is that the decision you seek to review is not going to stop unless there's an interdict. That decision will be implemented generally unless you have a very conscious decision maker who say that I'm going to stop the effectiveness and implementation of this decision until litigation between us is completed. But generally, absent an interdict, a decision that is subject to review gives rise to legal consequences and is capable of legal implementation. And it may well be that by the time the review proceedings are concluded, there has been a fundamental change on the ground because of the continued implementation of that decision. And so the court is not bound to grant the type of remedy you seek, and therefore ignore the concrete reality that has taken place between the institution of proceedings and the completion of the review proceedings. So that's a foundational basis on which the courts have invested upon themselves the power to grant a remedy which is just and equitable. Now, therein lies the tactics for a review applicant and review respondent. If I were to represent a public entity that is a subject matter of review, the ultimate tactic I would explore is to delay and delay and delay the finalization of the review so that by the time we get to court and my opponent succeeds, so look, the case is moot. There is no longer a need for the court to give judgment because the decision that you seek to review has come to an end, or the reality on the ground has so fundamentally shifted that there's no need for the court to intervene. One of the tactics around remedy, and so I suggested to you earlier that think through about remedy quite properly from the beginning. Now, on remedies, I'd like to explore some well-known, established type of remedies you may wish to invoke in review after you have thought carefully and applied your mind to your client's consent, whether as a review applicant or a review respondent. The first, from the applicant's side of review litigation, is obviously you want to set aside the decision you complain about. You don't want it to exist as a matter of fact and law. You want to set aside. And that's why traditionally we say review and set aside the decision. It may well be that in addition to those traditional lines of remedial powers, you ask the court to correct the decision. And therefore you ask the court to intervene by correcting that decision. Traditional rules of remedy. You may also wish traditionally to say, once you have set aside and corrected the decision, refer it back to the decision maker for reconsideration, providing that as a review applicant, time is on your side. Or you may say those are the traditional lines of remedies, but they're not enough for me. I want special forms of remedy. One of which is gaining traction generally. And in recent times, if you want the court to take over the decision that the decision maker ought to make, and the court substitute its own decision for that of the decision maker. We call it the remedy of substitution. It's an extraordinary remedy because generally reviews are not about takeover powers by the courts. They are about respecting the principle of separation of powers. and making courts understand that their duty is simply to supervise and monitor the correct exercise of power and not to take over the actual exercise of those powers. But there are cases where courts may well intervene because there would not be any need to respect the sensitivities around separation of powers. Take, for example, where you're faced with a decision maker who's totally biased against you. What is the point of taking the decision back to them? Or a decision maker who truly has a motive not to properly, faithfully, and in good faith exercise his or her power. What is the point? And so in that context, a court may well say that I intervene, I take over the powers to make the decision from the decision maker and unmake that decision for him or her. But you have to show exceptional circumstances because courts do not likely take over powers of decision makers. The third area of controversy from the perspective of a review applicant relates to supervision. There are areas of the exercise of power where a court may well feel that, but I don't have true expertise to take over the powers of a decision maker, because those decisions are invested in an arrangement, whether public, private, or quasi-public or private in the middle, that requires some form of expertise. And the court, generally, there are general practitioners invested with legal expertise and not technical expertise. And courts would be worried to take over those technical powers of a decision maker. What do? If truly they have to intervene in exceptional circumstances, the court may well devise what we call powers of supervision and create some kind of intervention where the courts would require the decision maker to implement its order by reporting to the court at regular intervals how that decision is implemented in the light of the court's order. We call that structural interdicts or supervisory interdicts. And that is one of the tactical remedial exercises we wish to consider in case the court says to you, but I don't have the expertise to intervene by way of substitution. From the side of the review respondent, remedial debates and tactics around it are quite interesting. Of course, I said to you, you may drag out the review and plead mootness as remedy. The other form of legitimate remedial tactic you can consider as a review respondent is to plead mea culpa and say, no, I was wrong. But I was wrong in good faith. And you ask the court to suspend its review intervention powers pending a corrective exercise on your part. The remedy of suspension is well known, and courts at times do come to the assistance of decision makers when the degree and extent of the mistake is genuine and reflects an honest but improper or illegal exercise of power. And the courts would intervene by suspending the consequences of its decision to intervene pending corrective action by the decision maker. And it's a remedy that we employ more often than not when we find ourselves representing review respondents who, for good reason, made a legitimate mistake. Well, I'd like to make some few concluding remarks, unless there are questions. I think it's becoming cold now. Yes.